learning outcome. After studying this module, you shall be able to know about the significance of expert testimony, the concept and validity of expert evidence, the practice and the approach of expert evidence. Introduction. The word forensics means presenting and interpreting scientific information in the court. Forensic experts study evidence at the scene of a crime, especially bodies of a crime. Forensic science provides evidence to prove suspect innocent or guilty. The conclusions of testing of scientific evidence is to be presented in the court of law. Therefore, presenting testimony in the court of law is one of the most important duty of any forensic scientist. For this, he or she has to be an expert in a particular field of forensic science. The expertise of the professional scientist can be of no value unless it is properly presented in the court of law. It is a fundamental principle of law of evidence that witnesses should state facts which are within their knowledge. Forming an opinion as to any matter of inquiry is essentially under the domains of the court. On some occasion, court may not be in a position to form judgment without the aid of an expert. The forensic expert who assists the court examine a wide variety of physical evidences associated with crime in their laboratories. Under such situation, the rules is relaxed and the conclusion drawn from a set of facts by a specially skilled person called expert are admitted as evidence under provisions of Section 45 of Indian Evidence Act. Required experiments are conducted, observations are made, data are collected, conclusions are drawn, and report is prepared and then submitted to the court. The report is based on well-established scientific principles and techniques well accepted by scientific communities. Under Section 293 of CRPC, an expert opinion is admissible in the court even without his personal attendance. The court can, however, order the expert for personal attendance if the court deems it fit. On the basis of the report of the expert, it depends whether a person is guilty or innocent. In many criminal trials, the forensic experts are cross-examined to testify their methods and conclusion drawn to understand and appreciate the evidence in a better way. The court thus rely more on expert evidence after they are examined. Courts have been usual to act on the opinion of expert from very early times, but the procedures used for trial was different. Before 16th century, the trial was merely a summation of mechanical process of a proof. At that time, there was no person named as an expert. Cases were pursued by rational men using logic process upon the information present before them. Witnesses acquainted with the case facts were involved in the jury panel. For the first time in 1562, witnesses were compelled to attend the court and testify in the court of law. At that time, courts used two types of method, including a M-panel, a qualified jury to pass judgment in a particular case, and to summon skilled persons to inform it about matter beyond its knowledge. By the middle of 17th century, the office of the jury had become clearly distinct from that of the witness. The party system of expert had started by the middle of 18th century. Now we will be discussing these things in detail.
Now, let us have a look on forensic expert testimony. The evolution of the concept of expertise is one of the path-breaking achievements of the legal system. Expertise involves an interaction between different subjects. Through this interaction, what law aims is to acquire knowledge is outside the ambit of non-expert fact finders. Courts are expected to hear and determine all the cases that come before them. They cannot escape from their duty by saying that the case cannot be disposed of due to the non-existence of judicial techniques. Therefore, judges in their everyday life depend on experts' testimony generally and more specifically. Moreover, as a consequence of advances in science and technology, there has been an increasing necessity of court of law to rely on expert testimony. Forensic science has become a handmaid of the law enforcement authorities. Criminal investigation is largely centered in the forensic science labs. So, the scientific proof has become inevitable in criminal issues. It covers a large number of disciplines with science at its nucleus. Modern technology and recent advances in scientific area have enlarged the scope of forensic science. It is also a well accepted fact that the data obtained in a forensic science laboratory have no use if it is not explained before a court of law. Here, experts play an important role in communicating valuable information necessary for a just decision. It is the expert witness who will act as a vehicle in the transmission of knowledge, which is outside of the mental faculty of non-expert judges. Through this process, they are conveying scientific terms in an easiest manner understandable to a layman. An expert is a person who by training, education, experience or a combination is able to assess the trier of fact by offering opinion concerning matters in question. Therefore, prior matter which must be obtained from an expert witness are the training, education and experience. Usually, the side calling the expert may request to be allowed to go into the expert's background, and at some point the judge will be asked to rule whether the witness is an expert. If the judge decides that the witness is an expert, then questions relevant to case and within the expertise of the witness are allowed and required opinion based upon observations. A general understanding of the process may help lessen dread about the expert's role in the legal system. Experts are allowed to render opinions about matters in legal proceeding because of their capability and experience. Experts may be called on to assist in the investigation and trial. The expert transmits knowledge to case facts and he or she is likely to be questioned. Expert should be preparative for cross-examination and answering vulnerable areas. Forensic experts must prepare thoroughly to testify. Cross-examinations can facilitate to boost confidence. Now, let us have a brief look on legal prominence of expert testimony. The law of evidence allows an opinion of any person other than the judge as to existence of the fact in issue that are relevant to a matter. The judge is not expected to be an expert in all fields, especially where the subject matters engage technical or specialized knowledge. In these circumstances, he needs to help of an expert having with superior knowledge or experience in relation to the subject matter. An expert is a person having special and high level knowledge of a picky subject. When such an individual is asked to testify with concern to his specialized knowledge, he or she is impounded to be an expert witness. The job of an expert witness is to help and determine the issues in argument by providing the court with information which is probable to be outside the knowledge and experience of the judge. The person must gain the approval of the court and should testify about facts rather than the law unless he or she has been asked to testify with consideration to his or her particular knowledge of law. The judge should make sure that the expert is qualified on the disputed issue and only pertinent and reliable opinions are accepted from him or her. There is no threshold test in general law of the admissibility of expert evidence which determine steadfastness, and it is at the judge's discretion to admit it or not. In the modern world, expert evidence plays an important role in determining a causal link between conduct and the harm suffered. An expert witness can be fixed either by party or court. Their opinion is useful in both civil and criminal cases. Till 1954, the subject of expert testimony was confined to foreign law, science, art, and the credential of handwriting or fingerprint impressions. At one time, only medical doctors, engineers, architects, stockbrokers, etc. were called as an expert witness. Now, the advancement in science and technology has no longer confined to a select few scientists in many fields to testify in court. Ballistic experts, chemical examiners, forensic psychiatrists, and even track dogs play a vital role in the investigation of crimes. Examining question documents in a prejudiced decision making deal, it happens that you may be working in a large laboratory with other document examiners, but when the examiner's name on the report is yours, you solely are responsible for the conclusion. You will be expected to show judges and jurors why you believe you are right. Therefore, a forensic document examiner usually resolves evidence puzzles and also convince court that your opinion is correct. Hence, the opinion of a person who has special skill in a particular field shall be admissible in the court of law. In spite of expectations to this rule, if there is a dearth of direct evidence and affirmation is required for already existing evidence, the expert's opinion is required and can be used as evidence. Now, dear students, let me tell you about qualities of an effective expert. Key qualities help determine an effective, credible expert witness. The expert must be personable, genuine and natural, demonstrate effective teaching ability, be prepared, competent and believable, be persuasive, not advocative about factual accuracy. Now let us have a look on forensic expert's role. The essence of the forensic expert's role in the judicial process is to assist the trier of fact in understanding complex scientific and technical issues. This explanation may include rendering an expert opinion. The forensic expert's role may include being involved at various stages of a case, including assignment, investigation, preliminary report, formal discovery, final report, pre-trial preparation, trial and post-trial. The expert's written report includes basic case and evidence identification and dates, conclusions and opinions, reasons supporting conclusions and opinions, and lastly, rationally and interrelationship between conclusions and the supporting reasons for those opinions. Now, let me tell you something about cross-examination. The expert witness may be called upon to retrace his step, explain and justify his position, and harmonize his view in the case with prior writings, depositions, or trial testimony from other matter or cases. Cross-examination is one of the most misunderstood aspects within the adversarial system. It need not be a fearful experience for the expert. Cross-examination is designed to guarantee a fair trial. With regard to experts, cross-examination has 6 general purposes. These are to establish lack of perceptive capacity or application, inadequate recollection of the applicable facts, bias, prejudice or interest in the outcome, questionable character, reputation or qualifications, prior inconsistent statements or conducts, inconsistency with recognized published authorities, so-called learned treatises. Now, cross-examination can present an opportunity to solidify and drive home the expert's conclusion and opinions previously stated during direct examination. Witness should be honest and should rely on their technical expertise and the scientific method on which their testimony is based. They should provide credible and effective expert testimony and should be able to use cross-examination in a very positive way. Now, qualities involve the professional's ability to speak with the trier of the fact. Higher communication skills make sure the audience doesn't wander away in what the professional is making an attempt to mention. Behavior additionally communicates one thing to the jury, that the credible professional is going to be skilled in look and speak with confidence while not being sniffy. Several criminal and civil investigations communicate expert witnesses in court to assist resolve cases wherever the facts are unclear or in would like of some clarification. Expert witness may be of one who will give information and opinion drawn from the body of information that produces up their own space of experience. Now, expert witnesses doesn't have to be wrongfully qualified. Normally, the witness is going to be a forensic man of science or forensic specialist providing information outside the realm of public knowledge regarding the circumstances of against the law. Document examiners and structural engineers could also be known as interviewees and provide proof, as might those from non-scientific disciplines as various as arts, climb or martial arts. Either prosecution or the defense might decision in expert witness. Then in this chapter we have come to know that the expert witness will expect to be cross-examined by the opposing counsel. That is, expert witness for the prosecution is going to be questioned by lawyers for the defense and vice versa. Professional testimony is particularly vital once different proof is poor to assist return to a transparent finding of fact. At identical time during a stalemate state of affairs, the witness should stay utterly unbiased. Then we have learned in this chapter that expert witnesses have a requirement to present apothegmatic, detailed and clear answers to any or all the queries placed to them. Then we have come to know that experts need to have an intensive understanding of the procedures of the court and also the proof acceptableness customary in their jurisdiction. Lastly, in this chapter we have learned whereas the rules might vary below civil and legal code, and whether or not the professional seems for the state of suspect during a criminal case, that professional should show no bias in action or clarification. However, demonstrate scientific objectiveness throughout his entire involvement during a case. That would be it. Thank you.